Okay, we're ready to finish up in this secured transactions chapter. And the last thing we're going to be talking about is what happens upon default. And we're going to take a look at the repossession process and the rights of the creditor and the debtor throughout this process. So let's start with this idea of default. Default is the failure of a debtor to meet an obligation of the security agreement. And most of the time this means not making the required payments. Usually when we look at this, we're referring to the debtor who has borrowed money and then is now not paying it back on time or at all. However, there can be other obligations that would amount to default. One, like I've mentioned, is not maintaining insurance. Sometimes the security agreement will require the debtor to maintain insurance on the collateral and they let it lapse. That could be a default. Filing for bankruptcy protection could be considered a default. All of those things are not meeting the obligations of the original security agreement. That's when a default happens. So what does the secured party get? If we have a valid security interest, it's attached, maybe even it's perfected, what does that entitle us to do? Well, let's take a look. We have options. As a secured party, once the debtor defaults, we can either repossess the collateral and then go through the repossession process that we'll talk about in a second, and or one or the other. So we can repossess the collateral and or file a lawsuit against the debtor for the money owed. Not necessarily both. Creditors aren't required to repossess collateral just because they have a security interest. They can just file a lawsuit for breach of the contract, which is basically the security agreement, for not repaying the loan and get a money judgment if they want. And they also have the right of repossession. I used to do some work for banks where we would, do these types of lawsuits where we would, unfortunately have to sue debtors who didn't make maybe their car payments and these kinds of things, where they had a vehicle that was a collateral and they didn't understand this rule, that they thought the bank had to repossess the car. And sometimes the car was in such bad shape the bank didn't want it back, to be honest. And so they didn't want to go through this repossession process, and they just wanted to go straight to a judgment from a court, a money judgment. And the debtor would object and say, no, take my car, please. Because they wanted at least part of that obligation to be satisfied through the value of the car, which is, of course, now worthless. But understand that just because a secured party has a security interest and has collateral, they don't have to exercise their right to repossession. Okay, so let's talk about repossession and what that's about and what the rules and the rights are. Secured party taking control or possession of collateral upon default is considered a repossession. Okay, there's a couple of ways to do this. One, we can go to court. We can go to court and get a court order allowing us, by court order, to repossess, go take away from the debtor and change possession from the debtor to the creditor, the collateral. Or, and this is what gets all the press and the attention, we have what we call a self-help right of repossession under the code. This allows the creditor, him or herself, without going to court first, to go along and repossess certain property, as long as, and here's the main rule, we can do self-help repossession as long as there's no breach of the peace. Well, and this is kind of a broad concept, but breach of the peace, for the most part, means without breaking any laws or doing anything unlawful. So we can't, for instance, trespass to repossess. We can't get into, a fight, a physical altercation to repossess. That's a breach of the peace. So as long as we can do so peacefully, then this right of self-help repossession will be effective. If looks like for the creditor there is going to be a breach of the peace, then the creditor really should go to court and get a court order, and that should eliminate any of those problems. We can get the sheriff involved and all those kinds of things. And by the way, like I mentioned, I used to do some work for banks, and from time to time the bank would want to go do a repossession, and I always wanted to go with them because I thought it would be really cool to go out, and be the repo man and everything. And so one time a local bank asked me to go with them. It was after hours, and the bank owner didn't have anybody to go help, and wanted me to go as a second driver. So We were going to go in his car, and then he was going to go repossess the debtor's car, and then I was going to drive one of the cars back. And I thought, yeah, cool, right? I get to be like, tough and intimidator, and repo man and all that. Well, it turns out it really wasn't very exciting because the debtor knew we were coming. The debtor actually handed us the keys because he knew what was coming. So it was kind of anticlimactic, but still fun nonetheless, for some law geek like me. Anyway, let's talk about what happens then. How do we dispose of the collateral? Once we repossess it, what does that give the secured party the right to do with it? Well, that's what we're talking about here. Disposition of the collateral. The secured party may dispose of the collateral in what we call any commercially reasonable means. All right, again, a broad phrase that's kind of construed broadly, but basically what that means is a sale, usually a public or private sale. If it's a public sale, we have to advertise for it, make sure that we have people that are going to show up and bid on the car, that kind of thing, or whatever the collateral is. I normally revert to vehicles because those are the ones we normally see repossessed or usually see repossessed. Or it could be a private sale, but if it's a private sale, it has to be done in a commercially reasonable means, right? And how do we enforce that? Well, the creditor must give the debtor notice of the sale to ensure a reasonable sale because the debtor has an interest in this. The debtor wants to make sure that the creditor gets as much as they can out of the collateral in order to satisfy the obligation. So the debtor could actually complain. For instance, if the bank repossessed a vehicle and then sold it to one of the bank owner's buddies really cheaply, for half of the fair market value or half of the value that they could have otherwise gotten at a repossession sale, then the debtor might complain and say, wait, you sold this to like a friend or an insider, with a sweetheart deal, and I didn't get as much credit out of the sale of the collateral as I could have. Right? And so for this reason, the creditor must give notice to the debtor of the time and the date of the sale so that the debtor can kind of keep tabs and make sure that everything goes according to, above board, that it's all reasonable. Okay, so after the sale, what do we do with the proceeds? Once we do a commercially reasonable sale of the collateral, what do we do with the money? Well, this is how it gets applied. The proceeds are applied first to the expenses of the sale. All right, so if we have lawyer's fees that the creditor incurs in going about this process and preparing the sale and all the documents necessary for it, those get paid first. Right? Why do you think so? Well, because the lawyers wrote these rules, right, in the UCC. So, of course, we get the expenses of the sale first. Advertising, if we have an auctioneer, or a salesperson, that person gets paid first from the proceeds. Next goes to the outstanding debt, the principal, right? Actually, we can break this down because the first amounts go to the expenses of the sale. The second amounts actually go to any accrued interest. Then we go to the principal of the outstanding debt. So that's kind of one step in there that I didn't mention specifically. But first we go to interest accrued, then principal. Then, if there happened to be more money left over than what the debtor still owed to the creditor, it could happen. It doesn't very often. Very rarely is there a surplus, but that's what we call it. So if the debtor owed $5,000, there was $1,000 in expenses and interest, that's $6,000, but the collateral sells for $8,000. Well, we satisfy all those obligations in the order mentioned, and then the remaining $2,000 actually goes back to the debtor because it was, after all, the debtor's collateral. The debtor owned that property that was sold, and that's what's called a surplus. Like I said, it's possible, rarely ever happens. Okay, usually it's the other way. And that's what we're going to talk about here. Usually there's a deficiency, right? There could be a surplus if the commercially reasonable sale yields more than the obligation. But usually there's a deficiency created after the sale. Amount of debt remaining after the sale of collateral. The debtor is still personally liable for that amount. And this is something that a lot of debtors don't understand. And I had to do a lot of explaining in these cases where we did repossession. For instance, of a car loan. So we would go repossess the car. The debtor owes $8,000. We sell the car for $5,000. The debtor thinks, well, that's the end of it. I lost my car, and now at least my obligation to the bank is satisfied. But then we had to explain to them, no, the vehicle was collateral, which means security for payment. It's not the full payment. It just secures payment. for the bank. And so then we had to explain to them, you're still personally liable for that deficiency, that $3,000 that the collateral didn't cover. And then a personal judgment is entered for that amount, which then can be collected through the court process, wage garnishments and other attachments and things like that. So what if the creditor doesn't conduct a commercially reasonable sale? If the creditor conducts a commercially unreasonable sale, again, this is like a sale on the cheap to an insider or relative or something like that, then a court has the discretion to reduce any deficiency amount that would have existed had the sale been reasonable. So what we do here is the judge looks at the sale and says, well, wait a minute. You sold this car or this collateral to your buddy at a big discount. Normally, fair market value of the car would be about $5,000. You sold it to your buddy for $1,000, creditor. So then when the creditor comes in to get a big deficiency judgment, the judge could or has the discretion based on the evidence to say, no, I'm not going to grant you the whole deficiency because I think you conducted a commercially unreasonable sale. I think you could have gotten $5,000 for the car. And so instead of giving you a $7,000 deficiency, I'm only going to give you $2,000 because I think you could have gotten more had you done the sale reasonably. So that's the judge's discretion, and that's a risk for the creditor. Okay, there is this other way of disposing of the collateral upon default, and that's something called acceptance of the collateral. A creditor may actually keep the collateral for him or herself. They go repossess it, and then rather than turn around and sell it and apply the proceeds, they could keep it. They could just keep it and use it, themselves. But there's some rules associated with this when creditors do it. First, the creditor must notify the debtor that they're going to keep the collateral in satisfaction of the debt. And if the debtor agrees, I should say only if the debtor agrees, then the creditor may keep the collateral in either full or partial satisfaction of the debt. Okay, so let's just use a vehicle because, again, that's the most common and maybe the easiest to understand in terms of repossession of collateral. So we have a bank, they make a car loan, debtor doesn't return, doesn't make the payments, is in default. The creditor wants to go and repossess. The creditor, let's say, bank president wants a new car and so wants to keep the collateral for him or herself. Maybe this is, maybe it's even not a consumer loan. Maybe this is a business loan and it's like a delivery van or something. And so the creditor says, well, we need a van here at the bank, and so I just want to keep the collateral in satisfaction of the debt. Now, if the debtor agrees to that, that's fine. And one other step. Let's say that the debtor owes a total of $8,000 remaining at the time of default. The bank says, we want to keep the van, but we want to keep it in only partial satisfaction of the obligation. And in essence, we'll credit you $6,000. We think that's about the fair market value of the van. And we'll credit your account $6,000. You still owe us $2,000, a deficiency at the end. If the debtor rather agrees to that, then that's fine. Creditor can do that. They can keep the van themselves and get a deficiency of $2,000, which the debtor would still owe. If the debtor refuses, though, the debtor could say, no, you can keep the van, but I don't want any further obligation. If you keep it, you keep it in full satisfaction. All right. Then if the creditor agrees to that, then the obligation of the debtor is satisfied. Right. So we can keep it either in full or partial satisfaction of the debt, but the debtor has to agree to that. If the debtor is silent after being notified that the creditor wants to keep the collateral in satisfaction of the debt, and then the debtor doesn't respond, doesn't specifically agree or disagree, the creditor can keep the collateral, but only in full satisfaction of the debt. Okay, so watch those rules there. And then there's a rule of consumer goods. Consumer goods are always treated a little bit differently, and so here's another example of that. The creditor may not accept consumer goods in the possession of the debtor. In other words, if the collateral is a washing machine, I can't go to the debtor's house, pull out the washing machine and put it in my house, because that's a consumer good, and it was in the debtor's possession. And I can't do that. There's just a flat rule on that. Or for which the debtor has paid 60% or more of the purchase price. So even if it's consumer goods and it's not in possession of the debtor, and the debtor has paid more than 60%, as a creditor, I can't go repossess it and keep it. I've got to sell it. I can't keep it in satisfaction of the debt. So just watch those rules a little bit. Okay, right down here now to the end. We do have, the debtor does have some rights, and that's what we're going to talk about here. The debtor has the right of what we call redemption. The right of redemption says that at any point prior to the disposition of the collateral, so right up to where it's disposed or sold, the debtor has the right to redeem it, to get it back, to keep it. But the right of redemption says that the debtor must pay all of the outstanding obligations, right? They pay the entire balance due, including any expenses created by the default. So if the debtor is somehow able to gather together enough money to satisfy all the obligations, including now any expenses related to repossession, any accrued interest, and all the principal, everything that's owed before the sale, right up to the time of the sale, they have the right to redeem it. All they have to do is go to the creditor and give them a check, or give them, I'm not sure a creditor would take a check in that example, but some sort of payment, cash or whatever, a cashier's check from another bank. In fact, that's usually how it happens, is that the debtor is able to find another lender who says, okay, I'll loan you the money to pay off everything, just allow you to keep the collateral, and then there's a new obligation created at that second lender. But the debtor has the right of redemption right up to the time of the disposition of the collateral. And then at the end, if the debtor doesn't default, right? I mean, it happens. I don't want to give you the impression that every debtor defaults on all their obligations all the time. That's just what we get to talk about in this chapter. But if the debtor does fulfill their obligation, right, pay off the loan or whatever their obligation is, then there's something called a termination statement that may need to be filed. So if we have a secured creditor who has perfected their security interest by filing, well, that filing is out there at the Secretary of State's office, and it stays there on file. Right? So what do we do about that if the debtor then goes ahead and satisfies the obligation? We want to get rid of that security interest. We want to let everybody know that it's no longer valid. It's been paid. And so that security interest has gone away. How do we do that? We file another document called a termination statement. So in the public records, we have the UCC, what we call the UCC-1, the financing statement that's filed with the Secretary of State. And then when the debtor satisfies the obligation, we have another document, the termination statement document. So anybody searching will see both of those and realize, this is free and clear collateral, so I can go ahead and use it now for security interest. If the debtor does not default, then the secured party must file or give to the debtor a termination statement within 20 days. Right? So, and this is something I would just kind of caution you all listening to this, because some of you may be debtors in this situation where you have personal property as collateral and you pay it off. Banks are sort of notorious for being slow to give you the termination statement or forgetting about it altogether, because after all, at this point, once you've satisfied your obligation, there's nothing left in it for them. They've been paid. So they don't really have a lot of incentive, other than the UCC and the law itself, to go ahead with this termination statement. So sometimes they kind of drag their feet or they forget altogether. Right? So sometimes you have to get on them. But the law says, UCC Article 9 says that if you've satisfied your obligation, then they have to file or give you as the debtor within 20 days of your satisfaction of the obligation this termination statement. And then down here at the bottom, consumers, again, this is a little bit different because it's consumer goods. But if the obligation is satisfied and the collateral was consumer goods, then there's a slightly different rule and it favors the consumer. The secured creditor must file the termination statement within a month of the satisfaction of the obligation, or 20 days if the debtor demands it. Okay, so in this case, it's not just they give you the termination statement that you have to go file. It's that they have to file it, and they have to do it within a timely manner, and even a shorter period if you as the consumer